this matter would have gone before another judge, and that's an old man. So, appeal to your audience, tone it down. It doesn't benefit anyone. Fortunately, I don't take the line that if you insult me, then I will take you on Contempt. I love to control. They can insult me the way they want, but at least don't extend those insults. Threats. That's about housekeeping. I hope the point is made. Edgy, can we listen to you? Edgy, how where to see and then the So, edgy, have you replied to the application? Can you take us back point by point why you oppose the application?
My Lord, for record, again, I'm John Nakwera, and I'm a senior secretary.
Francis.
My Lord, the application for you and us all is for habeas corpus. And for habeas corpus, it has elements that you must prove for it to be granted. One is that a person or the applicant was arrested. The said applicant is in detention, whether by state or anyone else. And that the detention is illegal. It's not in contention that the applicants were arrested and are in detention. The only issue is whether their detention is legal or illegal. And it is our contention that their detention is lawful. Your Lordship, we are not here to review the Supreme Court decision. Yes. Absolutely. And this is not the purpose of this application. The Land Honorable Chief Justice wrote about 200 pages, elaborate judgments, and it is self-explanatory. And it's straight law, my Lord, that any person who feels the application or the judgment of court cannot be construed in the way they feel it should, they applied the same court that issued it for clarification. My Lord, I'm not here to impose words, interpretations, because I'm not qualified to interpret the judgment of Supreme Court otherwise expressly given. Yes, and that's what I've said. I'm not here to interpret it otherwise as expressly given. Your Lordship, my boss, the Lord Mayor, who is part of this government, has elaborately read through the orders of Supreme Court. And if any case, you will be on my side, defending government. He has elaborately read through the orders of court, dot by dot, word by word, and nowhere did the court say release. It only gave an order of transfer. Transfer all the files which are pending before the court martial to courts of civil courts. And from our affidavit, deposed by Mr. George Karimera, the Land Commissioner of Civil Litigation, he has ably indicated to you steps taken from 31st of January when the judgment of Supreme Court was granted. I will not go through all the steps taken, but I can only take a brief that on 31st January, the Supreme Court indeed gave that judgment. Most importantly, the court ordered that all charges or ongoing criminal trials or pending trials before the court-martial involving civilians must cease and be transferred to the ordinary courts of law with competent jurisdiction. To fulfill and implement the orders of court, on 3rd February, government commenced the implementation. We wrote to the Chief Justice, the Land Attorney General wrote to the Chief Justice requesting for a liaison contact on how transfer of files can be managed. On 4th February, the Chief Justice appointed the Principal Judge as the liaison contact and instructed him that all matters should be handled by himself.
So, if I now sit here trying to unquote myself in the role of the principal judge.
I'm coming to that, my lord. However, I didn't want it push it into your mouth. But since you have already said it, my lord, I take it, and that is the position of the respondent. And on 6th February, my lord, the Attorney General forwarded the Chief Justice's instructions to Minister of Defense and the Office of DPP. And on 13th February, that's when we received a decree from the Land Council for the applicants in the case of the respondent, in the case of Attorney General versus Ageesigika. And on 17th, the same was signed by both parties. My lord, Article 28 refers to fair hearing and a speedy trial. Speedy trial and fair hearing is not one-sided. It is both parties. In this case, the applicants and the state. The state has taken action to implement the orders of court. The orders of court are clear to transfer the files. And it's not in contention that indeed the applicants had been charged at court martial and they had been remanded and there was a warrant for their remand. If the Supreme Court wanted to cancel the remand warrant, it wouldn't have taken a paragraph after almost 200 pages to mention so. It only said transfer the file to ordinary courts. And that's what the state is doing. It will be contempt of court, the Supreme Court, for this court to order otherwise. And also if Attorney General had not acted the way he has acted. the fact that the Supreme Court ordered transfer and did not nullify or order release all the accused in the court martial. And for your information, my lord, it's not the applicants alone who were before the court martial. There are many. The fact that there is no order on court record. I have heard my land senior colleague, Honorable Segona, trying to explain what is not in the judgment of the Supreme Court. I don't know whether we have different copies of the same judgment, but there is nowhere where the Chief Justice said otherwise, apart from transfer. And if he wanted so, he would have mentioned. The fact that the Supreme Court did not say release, it was aware of what it was doing. And in that so, it validated all the orders that all the suspects are based on to be in prison. If it had deemed otherwise, a sentence of saying release, actually that word alone, release, would have been enough. But if there is any party that misconstrued the judgment of Supreme Court, the right forum is the Supreme Court. As an office of this court, Honorable, I need to guide that do not be misguided by my land colleagues from the other party. More surprised, my lord. More surprised. And I'm alive to the fact that you are a doctor-in-law. You would not be misled. So the aggrieved party in this circumstance, my lord, for the misinterpretation of the Supreme Court decision, it would go back to the same court that issued the same order, what it meant by saying this. It is in the interest of the state and for the people of Uganda that justice is done on both fronts. The biggest issue yes, my lord. I will not accuse the Supreme Court that it didn't give us a timeline. But however, from the reading of our evidence, the judgment was given on 31st January. Immediately, on Monday next week, which was 3rd, we acted, and the process is ongoing. We are not going, I cannot mention how many files are involved, but they are numerous. And the process of expediting the process is on course, and that's why the principal judge was allocated this responsibility. It would be premature and unlawful absolutely, absolutely, and it would be injustice, my lord, to say that slow speed. For example, this application was served on us last evening around 9 p.m. There is an affidavit on record. I didn't sleep. My team did not sleep. That Attorney General did not sleep. I was on phone up to midnight to respond, to ensure that justice is served on both fronts. My lord, in conclusion on my part, this application is misconceived because the applicants are aware that they are in detention legally, and the state is not denying where they are. And at any time you want to look at him, you can even visit him, anyone can visit him. And if anyone can want him to be produced in court, can be produced in court. but ordering his release would be in contempt of the Supreme Court decision. I so submit, my lord.